welcome to the deep dive. So, you've sent over quite a collection of materials.
Indeed. It looks like we have excerpts on damages, the specific relief you're asking for.
Yeah, and a breakdown of these alleged procedural issues, plus a definition of a petition and, your notes on the evidence itself.
Right. So the big task for us today, really, is to unpack all of this.
Exactly, and answer that central question. Looking at everything here, are we actually ready to take this petition to court?
That's the core of it. We need to dive in, see what's solid, maybe where there are still questions, and get a real sense of preparedness.
Okay, so let's start laying the groundwork. Where does this whole thing begin? What's the fundamental issue?
Well, the summary of procedural irregularities seems like the best place to start. It lists out 9 specific points where things allegedly went off track.
9, okay. What's the first one?
It highlights the initial trade dispute filing. Apparently, it listed 42 officers, but the argument is only 14 were properly involved or affected.
Ah, right. And that's flagged as what? Procedural fraud, breach of fairness.
Yes, potentially both. It raises questions about the very foundation of the case right from the get-go.
Okay, so a fundamental discrepancy about who this case even concerns. Why is that so important?
Well, if that initial list was wrong, it could, cast doubt on everything that followed. The second irregularity kind of flows from that, a failure to properly conciliate at the Ministry of Labor.
Conciliation. That's like the mandatory mediation step, right? Before court.
Exactly, an attempt to sort it out first. The claim here is that this duty wasn't met, which they argue is a breach of the duty itself and violates the protection of the law.
And the proof for that is?
Seems to be the Certificate of Unresolved Trade Dispute. The implication is that the process just didn't happen correctly at that stage.
Okay, so potential issues with who was listed and maybe the first attempt to resolve it wasn't done right. What's irregularity number 3?
This one's about delay. An 8-month gap, apparently, between getting that Certificate of Unresolved Dispute and actually filing the case in the industrial court.
8 months? That sounds significant.
It does. It's argued this amounts to a denial of timely justice, which is part of that right to a fair hearing within a reasonable time. You have to wonder what was happening or not happening during those months.
Yeah, definitely raises questions about efficiency, fairness.
Yeah.
Maybe prejudicing the petitioners.
Yeah.
What's next on the list? Number 4.
Number 4 is about the tribunal's decision. It found it had no jurisdiction based on a claim about a no branch board. But here's the kicker. That claim apparently wasn't formally pleaded or argued by the parties.
Hold on. So the tribunal ruled on something that wasn't even officially part of the case arguments.
That's the allegation. It's described as procedural abuse and a violation of natural justice. The basic idea that you should get a fair chance to respond to the claims against you.
Wow, okay. That seems like a major point challenging the very basis of the tribunal's decision. What about number 5?
Point 5 is about the reasons for that ruling. It notes a lack of proper written reasons when the tribunal gave its initial oral ruling.
Ah. So they said what they decided, but didn't immediately provide the written why.
Seems so. And the argument is that written reasons are crucial, right? For transparency, understanding the logic, deciding whether to appeal, not having them promptly is framed as a breach of duty and denying due process.
Makes sense. You need the details to know what you're dealing with. Wow. Okay, number 6.
Number 6 is another significant delay. This time, about 11 months between hearings back in 2017 and 2018, apparently without good reason.
Another delay.
Yeah, and again, it's framed as violating that right to a fair hearing within a reasonable time. These repeated delays certainly paint a picture.
They really do. It starts to look like a pattern. Okay, what's number 7?
7 highlights an inconsistency. It seems 14 officers were involved in the judicial review stage, but then filings for the Privy Council appeal mention 42 officers.
Wait, the number changed again, from 14 back up to 42 later on?
That's what's alleged. This discrepancy is labeled potential procedural manipulation, violating due process, and sort of the certainty you expect in legal proceedings. That kind of jump is definitely a red flag.
Absolutely. You'd need a very clear explanation for that. What are the last 2 irregularities, 8 and 9?
8 relates to the Privy Council appeal process itself. Conditional leave to appeal was granted in September 2021, but the actual registration with the Privy Council didn't happen until April 2022.
Another delay, but this time in the appeal mechanics.
Exactly. A delay in formally perfecting the appeal rights, seen as another procedural hiccup. And finally, number 9 is about the delay in the Privy Council hearing itself. It only happened in February 2024, despite registration back in April 2022.
So a long wait for the final hearing, too.
A very long wait. Argued as excessive delay, again violating the right to an expeditious resolution.
Okay, so if you take all 9 of these alleged issues together, the supporting proof document saying this isn't just a collection of errors, right?
Exactly. The conclusion drawn there is that these collectively point towards breaches of fundamental constitutional rights. Specifically, Section 4B, protection of the law, Section 5.2e, fair hearing in reasonable time, and Section 5.2, procedural fairness.
And the other evidence document, the evidence2.pdf, it reinforces this idea of a systemic problem.
Yes, it underscores that these alleged missteps form the bedrock of the argument that there's been a systemic denial of justice over a long period.
Okay, so that's the core grievance laid out. Now, we need to understand the tool being used to address the petition itself. What exactly is it?
Right. The source, what is a petition, helps here. It defines it pretty simply. A formal written request to a court asking for action or a remedy for a grievance.
So in our context, it's the formal document saying, here's what went wrong, please fix it.
Precisely. And the benefits listed in that source really resonate here. It gives access to justice, a formal way to seek a remedy. It amplifies the voices of, Victor Sandy and the others involved.
Gives them a platform.
Exactly. And potentially it can lead to accountability and maybe even drive changes in how these processes work in the future.
It also mentions it can be relatively straightforward and cost-effective, which seems important given the long history here. So how does this definition connect back to those 9 irregularities we just walked through?
The petition is the vehicle. It's how we take those specific alleged failures, the delays, the inconsistencies, the jurisdictional issues, and present them formally to the court, asking for intervention. It's step 1 in seeking that judicial remedy.
Got it. So we know the problems, we know the tool. What are we actually asking the court to do? What's the desired outcome? Let's look at the relief sought.
Okay, the pasted text document details this. First and foremost, a declaration, a formal statement from the court saying the petitioner's constitutional rights were in fact violated, specifically under sections 4A, 4B, and 5.2e.
So 4B is protection of the law, 5.2e is the fair hearing in reasonable time. What's 4A?
4A is the right to enjoyment of property and the right not to be deprived thereof except by due process of law. So covering fairness and timeliness, essentially.
Okay, so a formal acknowledgement of rights violations. Beyond that, there are financial remedies being sought too.
Oh, absolutely. Compensatory damages are requested. That's to cover the tangible and intangible losses, financial loss, missed opportunities, emotional distress, damage to reputation, basically trying to make them whole financially.
Right, compensation for the harm done. But there's more, isn't there? Vindicatory damages.
Yes. Vindicatory damages aren't just about the money loss. They're about the court affirming the importance of the constitutional rights themselves and recognizing how serious the violations were. It's about principle.
So compensation and a statement about the value of those rights.
Precisely. And then it goes further. Aggravated damages are also sought. This is specifically for alleged oppressive or humiliating treatment by public officials involved in the process.
Okay, acknowledging particularly bad conduct. And then there's exemplary damages, punitive damages.
Exactly. Exemplary or punitive damages. These aren't really about compensating the petitioners at all. They're aimed at punishing the wrongdoers, the state actors, and, crucially, deterring similar unconstitutional conduct by authorities in the future.
So making up for the loss, affirming the rights, acknowledging bad treatment, and sending a strong deterrent message. Quite comprehensive.
Very. And there's also a request for costs on an indemnity basis, basically asking the other side to cover all reasonable legal fees, plus that catch-all phrase, such further or other relief as the court may deem just.
A safety net.
No.
And the assessment of the document suggests this whole relief section is pretty solid.
Yes, it's described as strong, clear, and matches the constitutional law standard. It suggests that legal framing is sound and gives the judge scope to award different types of damages if the case is proven.
Okay, that's encouraging. We know what we want. But what's the argument for why these damages, especially the bigger ones like vindicatory and exemplary, are actually warranted here?
The damages argument document tackles that head on. The core argument is that these weren't just simple mistakes or minor oversights.
Right, it suggests something more deliberate.
Yes. It argues the breaches came from deliberate omissions, procedural manipulation, and a sustained pattern of institutional neglect over more than a decade. That's a very serious claim.
It absolutely is, suggesting intent, or at least persistent disregard, not just error.
Exactly. And the argument follows that that kind of pattern justifies more than just basic compensation. It demands full vindication of the rights and a strong signal that this won't be tolerated from public bodies.
So it breaks down the damages into those 4 dimensions you mentioned.
Yes. Compensation for loss, vindication of the right, recognition of aggravated harm, and punishment for systemic issues or abuse of power.
And the analysis of this argument is also positive.
It seems so. It says the section explains forcefully and legally that it lines up with relevant case law from Trinidad and the Privy Council, and it sort of sets the stage for the judge to potentially consider a really significant award.
Suggests the legal thinking is persuasive. Okay, so detailed list of alleged problems, check. Understanding the petition tool, check. Specific list of demands, check. Strong argument for those demands, check. How wide does the actual evidence connect all these pieces?
That's where the supporting proof document is key. It tries to create that direct link. For each of those 9 irregularities, it lists the specific proof being relied on.
Can you give an example?
Sure. For that first point about the 42 versus 14 officers, it points to Ministry of Labor records presumably showing both the initial filing and maybe a later correction. For the 8-month delay before the industrial court filing, it references the dates on the Certificate of Unresolved Dispute and the court's own filing records.
Okay, so for each claim of something going wrong, there's a specific document or record identified as the backing for that claim. We don't have every single page in front of us, but the structure seems to be there.
That's the idea. Grounding each allegation in specific documentation. And the evidence, 2.pdf, reinforces this by mentioning specific court filings, affidavits like one from a Clay Hackett, about timing, and pointing out how the Privy Council summary still mentioned 42 officers, even when the Court of Appeal had apparently settled on 14.
Right, showing that documented trail of inconsistencies we talked about.
Exactly. It aims to show this isn't just assertion, it's based on the case's own paper trail.
Okay, so bringing it all together now, based on everything we've looked at, the clear grievances, the supporting evidence cited, the well-argued damages claim, the specific relief sought, what's the assessment? Are we ready to face the court with this petition? How prepared does this look?
Well, based purely on these materials you've provided, the indicators for readiness look quite strong. You've got numerous alleged procedural failings, clearly linked, it seems, to constitutional rights. The arguments for damages, particularly the different types, appear legally sound and grounded in case law. The relief section is specific and comprehensive. It really looks like a substantial amount of groundwork has been done to build this case.
It does feel comprehensive, doesn't it? Like a lot of thought went into connecting the dots from the initial problems right through to the legal arguments and the evidence. Of course, presenting it in court is another challenge entirely.
Absolutely. How the evidence holds up, how the arguments land with the judge, that's the crucial next phase. But in terms of the preparation reflected in these documents, it suggests a high degree of readiness. The case seems well-defined and well-supported on paper.
I tend to agree. It feels like the core issues are identified, the legal basis is established, and the objectives are clear. So let's wrap up this deep dive. We've walked through the alleged procedural history, defined the petition itself, detailed what's being asked of the court, explored the arguments for damages, and touched on the evidence linking it all together. It certainly seems like a thorough effort.
It does.
So here's a final thought for you, the listener, to mull over. Given this detailed account of procedural twists and turns spanning years and the very significant relief being sought, what do you think might be the single biggest hurdle when this petition actually gets presented in court? Something to consider based on everything we've unpacked today.